if we look at most of the arguments for arbitration, and we analyse those arguments for arbitration in some detail, they tend to be fallible. So the arbitration argument that it's quicker, there's not a lot of evidence that arbitration is quicker than the court process. In some jurisdictions, absolutely it is quicker. But in many jurisdictions, there's no evidence that arbitration is quicker. At least less expensive. Again, there's very little evidence to show that the cost of arbitration is cheaper than the cost of the courts. In arbitration, you get experts. No. In arbitration, you get the people that are appointed by the protagonists. If I'm going to arbitration, I don't appoint an expert. I appoint a person who I believe will support the argument I want to make. And I expect the other side of the arbitration to do exactly the same thing. Appoint a person that's going to support the argument that I want to make in the arbitration. Now the two arbitrators may then, between themselves, in appointing the third arbitrator, appoint an expert. There has grown a practice of, rather than going to the courts, going to arbitration. Right. Now the courts are provided by the state. Arbitration is a process that's provided by the parties. Right? Okay? Now, the second part of your question is a very interesting part. Do you go to arbitration and then go to the courts? Well, there are some people that do adopt that approach, that you go to the arbitration, if you don't like the result, you go to the courts. Most people are not going to let you do that, okay? But the argument is that the reason arbitration is an effective resolution mechanism is speed, cost, you get experts to deal with your dispute. It's confidential, and that is true to a degree. Of course, if you take it on appeal and end up with the courts, the confidentiality is now gone. Right? But the truth of the matter is, a lot of the grounds given for arbitration as the preferred route don't really stack up to scrutiny. So another one that's often given is, if there's a weak legal system, by using arbitration, you end up with a strong legal system. No, you don't. You end up with the legal system that is effectively applied by the three people that you've appointed to carry out the arbitration. So I'm never convinced by the arbitration argument that, there are all these great advantages. But there are advantages, and we should recognise that. So there are times when, even if you do accept that courts have got a role over arbitration, you are better off going to arbitration. Let me give you another example. India. We were doing a contract in India, and we did the first draft of the contract. We sent it to the Indian Attorney General's office, and we had put Indian law, Indian courts. It came back Indian law, but Indian courts crossed out. And they had put in arbitration in Singapore. Now we thought this was very odd, because most states insist that not only is it Indian law, but it's also Indian courts. So we sent it back, put it back to Indian courts. No, it came back crossed out, arbitration in Singapore. Anyway, we accepted arbitration in Singapore the next time round. So the contract is signed, and we have your signing drink or dinner or whatever it is. So I spoke to the lawyer and I said to him, look, I don't understand why you kept crossing out Indian courts. And why were you insisting upon arbitration in Singapore? He said, well, if we closed the courts of India for the next 27 years, we would not clear the backlog of cases. You and I will not be here. We will not be alive by the time any dispute under this agreement comes before the courts. Right? And I intend to be there if there's any dispute under this agreement. And the only way I can be sure of being there is if I take it outside of the Indian court system and I put it into the arbitration system. Because irrespective of how slow the arbitration system is, it's not going to take 27 years. So there are good times for using arbitration over courts. From my perspective, it's a pragmatic approach. If the courts are efficient and effective, they are the most appropriate authority to deal with these issues. If they're not, then arbitration becomes a very good alternative. The final point I just want to say on arbitration is just remember that if you get an award, if you get a judgment of a foreign court, you have to find a way of enforcing it. So just make sure that the jurisdiction that you're working in is a party to the New York Convention, which enables you to enforce your judgments or your awards. There's nothing worse than getting a judgment and an award and not being able to do anything with it.